Hello, and thank you for joining us for guidance on OSHA's vaccination and testing emergency temporary standard for COVID-19. This program is part of the SHRM webcast series. You can learn about upcoming and on-demand events from our e-newsletters and the webcast homepage at shrm.org/webcast. SHRM thanks Unum for sponsoring this program and SHRM's series of free webcasts for the HR community. To accommodate as many viewers as possible, this program has been pre-recorded and is being made available at various times throughout the day and on demand. Because of that, we won't be able to field any questions for our speakers. The program features a series of discussions on OSHA's emergency temporary standard. We don't have content slides to show you or a PDF to download. However, in the program resources window on the left side of the player, there are links to resources you may find useful as you form your compliance strategy. You can also find these on the SHRM website at shrm.org. Scroll down on the homepage to the section titled Coronavirus and COVID-19 Resources. We want to point out the yellow button on the tray on the bottom of the webcast player. That will bring up a viewership certificate you'll be able to download toward the end of the program. It includes the SHRM Certification Research Credit Number. Viewing this full program qualifies for one PDC toward SHRM CP and SHRM SCP recertification from the Society for Human Resource Management. You can also claim this program for other kinds of HR recertification credit, but you'll need to provide the details to your certifying body. We only have the pre-approval code for SHRM certification. With those bits of housekeeping out of the way, we welcome Emily Dickens to the webcast microphone. She is SHRM's Corporate Secretary, Chief of Staff, and Head of Government Affairs, and she'll get our program underway. Ms. Dickens?
Well, welcome, SHRM members. I'm Emily Dickens, Chief of Staff and Head of Government Affairs here at SHRM. As you know, last Thursday, OSHA publicly released the highly anticipated Emergency Temporary Standard, or ETS, mandating that businesses with at least 100 employees require their workers to get vaccinated and or wear a mask and test for COVID-19 on at least a weekly basis. 2 days after the release of the ETS, a Fifth Circuit Federal Appeals Court temporarily suspended the rule, and in the following days, a ruling will be made on whether the new rule will be enforced. Regardless of the current state of the rule, we knew we had to provide programming on this issue because HR professionals are the experts in developing, administering, and executing workplace safety measures to protect the health and well-being of American workers. In addition, it is important for your organization to continue preparing for the ETS to be ready if the stay is lifted, as this OSHA ETS will directly affect your work in implementing all workplace statutes and fostering effective workplace culture. SHRM's been highly engaged with the White House, the Department of Labor, and OSHA on the ETS immediately following President Biden's September 9th announcement of the vaccine and testing mandate. At SHRM 21, while we were all in Las Vegas, per the request of the White House, SHRM conducted a short survey of member reactions to the President's announcement. A more comprehensive survey was sent to HR professionals and U.S. workers. Survey results released in October showed employers anticipated having great difficulty implementing the workplace vaccine mandate. SHRM also attended OSHA briefings on the mandate for federal contractors and subcontractors to better anticipate what shape the broader regulatory requirement might take. Because of our subject matter expertise, SHRM was selected by the White House Office of Information and Regulatory Affairs to participate in a meeting where we could share HR professionals' questions about the workplace vaccine mandate. Unfortunately, because there was no draft standard available to comment on, we, like all other members of the public, were unable to share with the administration how specific aspects of the ETS would function or not in the workplace. Because of concerns brought forward by SHRM members, we recommended that OSHA release a draft of any proposed mandate and incorporate public comment rather than requiring employers to meet an arbitrary standard drafted outside the normal rulemaking process. This approach would have allowed the HR community to provide concrete and actionable feedback rather than speculating on a non-existent rule. SHRM has been and will continue to be diligent in working to ensure the voices of HR professionals and business leaders are heard. On the day the ETS was released, the External Affairs team hosted an exclusive webcast for 18 members and deployed a survey of HR professionals on how the ETS will impact employers and employees. Yes, there are benefits of being a member of SHRM's A team because we hear from those voices the most and we wanted them to get the information as soon as possible. Now we want to provide you with more resources to make well-informed decisions for your organization. We've got an amazing program planned for you today that includes nationally recognized employment attorneys and HR thought leaders from our Knowledge Center to provide answers to some of your burning questions on the EPS. Before I hand it over to the next speaker, I want to make sure I say something I think many of you have heard me say before. SHRM's stance of policy, not politics. We're nonpartisan, and we're going to work with any and all administrations to ensure that SHRM is a partner and trusted advisor on all things work. We're not going to agree on everything, but our goal is to ensure that the voice of HR, your voice, is included in all policies related to work, workers, and the workplace. Thank you so much for your continued diligence in safeguarding workers' lives and livelihoods throughout this pandemic. On that note, I'm thrilled to introduce my colleague, Tony Lee, SHRM's Vice President of Content, who will lead you further in this discussion.
Thanks, Emily. I'd like to welcome Carol R. Mioskoff, Legal Counsel for the Equal Employment Opportunity Commission in Washington, D.C. Carol manages development of the Commission's regulations and guidance under the Americans with Disabilities Act, Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, the Equal Pay Act, and the Genetic Information Non-Discrimination Act. Carol, thank you for joining us.
Sure. Hi, good morning, and I'm happy to be here and happy to try to help out on some of these challenging topics.
Well, we really appreciate that. In light of OSHA releasing its emergency temporary standard last week, our members are saying that they're already seeing an increase in requests for religious accommodation among employees who prefer not to be vaccinated. So my first question, are there specific questions an employer may ask an employee related to a religious accommodation?
Thanks, Tony. That's a great place to start. And I will sort of answer that as, in reference to the fact that some employers are trying to design forms that people can use to make these requests. And I just want to say a few things. One, you do not have to design a form. Two, if you want a model form, EEOC's own form is posted online as part of our What You Should Know on the EEO laws and COVID. And it's online in section L as in Leonard, of our guidance. The bottom line is, though, that I want everyone to know in terms of specific questions. To start this process, you don't need to ask a lot of specific questions. All someone needs to do is say that they have a sincerely held religious belief or practice that puts them in conflict with this vaccination requirement. And that's enough to start the process, to make the request. I think it's wise to just keep this sort of starting moment as simple as possible, and not to spend a lot of time fussing about what a request form should look like ultimately, but just to keep it really simple. And like I said, EEOC's sample form that we're using internally is online. So we rarely put out the forms we use internally, but we're doing it here because there's so much need. Okay, I thought hopefully that will address that first question.
Yes, it does. Thank you so much, Carol. So the logical next question is, what do employers do if they believe an employee isn't being truthful about their religious beliefs, practices, or observances?
Sure. In a sense, this is a $64,000 question. And I'm not going to pretend that it's easy. It isn't. But I can do two things. One is tell you that EEOC's COVID guidance does address it in our What You Should Know at question L2. So you should read that. And then to give you an overview of what the answer is if you don't believe what someone's saying, that goes to whether or not it's a sincerely held religious belief. And essentially what you're saying is, I don't think it's really sincerely held religious belief. You're not questioning that it's religious per se, but you're saying, I don't believe it. what our guidance says is that you can definitely look for for indications of reasons not to believe it, like inconsistent conduct in the past, or I think a big one would be the timing of the request, i.e., if someone had said that for purely personal preference reasons and just just the way they are, they don't like tests, they don't like masks, they don't like any of this stuff. That would be a reason to question their sincerity. And then you can ask a few more questions at that point. You can ask questions about inconsistent conduct in the past, for example. You definitely can ask that. You have to be a little careful there because, while there may be some clear cases of someone who is totally non-religious, or who's doing everything that was contrary to these current religious beliefs, you're also going to have people whose religious beliefs have evolved and have changed. And religious beliefs do that. They morph over time. They expand, they contract, they change. So I think you have to be careful about denying someone an accommodation because you don't believe them. And if you do that, you need to record that you did ask them for specific questions about some prior conduct, have that in your records, and have notes of why you came to that conclusion.
Yeah, and I guess that also leads to the question of, well, can I request documentation or even require documentation, such as a signature from a religious leader attesting to the person's religious accommodation need?
Well, I wish I could say yes and that's the easy fix, but I can't. And I'll tell you why. Under Title VII and under, the way the Supreme Court interprets religion, religious beliefs are not limited to organized religion, to traditional organized religion, where you have a minister, you have a priest. So religion is broader than that. So that's not going to be definitive. The second reason is that people may give you things signed by someone who's a professed religious leader, but you may not believe them. So getting that, signed letter in and of itself is not a quick fix. So I think, the bottom line is that you do have to err in favor of believing people when they say they have a sincerely held religious belief. And, you can get behind that about inconsistent practices, etc. But you do have to lean in favor of just of accepting that.
What do you think are some of the most common misconceptions about the EEO laws as they apply to the employer vaccine policies?
What I think the biggest misconception is because we have to, under our law in America, have a broad interpretation of what's religion. Because of that, an employer has to grant absolutely every request. And that is a misconception. You don't. But I think what carries the water is the undue hardship prong. And that is, it's discussed again in our section L. I think the discussion of that starts in question L3. And we have several questions about it. And really what undue hardship comes down to is two things. If you're a smaller company, it comes down to money. And if you are a larger company, you can always look to disruption to the operation of your business. That is an undue hardship, that you simply can't get the work of the business done if you grant these accommodations. That is an undue hardship.
Yeah, that leads directly to kind of our key question that we've been hearing a lot,
Sure.
And which is, there are an awful lot of employers who are right on that cusp of 100 employees. And
Right.
I'm very curious, what's your response to employers that say they don't have the resources to cover the cost of testing, especially if a large group of employees request accommodation, but they're fearful of asking employees to cover the cost, so since they may quit. They may go across the street to a company with fewer than 100 employees. What would you say in that case?
What I would say is, number one, I totally get that this is hard. Number two, that what you need to do is start looking at this job by job, rather than, try to step back from looking at everyone, and try to look at the functions that people do. And, is there a way that someone could do that function and have an accommodation? And if you cannot afford to pay for any testing whatsoever, that there would be a way, say, in that job for the person to do the job on off hours, someplace, some way, shape, or form that will have sort of safety precautions for COVID to prevent the transmission of COVID from worker to worker. That's what this is all about. So you really need to look at each job and see what can be done. Can something be done if you're not going to pay for testing and the employee says they're not going to pay for it? Is there any way this person can be accommodated? Can they telework? If they can't telework, can they work at a different location, at a different workstation, et cetera? So you look at these things job by job. And if you can't accommodate them, if you can't pay for testing, you can say, well, you'll need to pay for a weekly test. And that'll be starting, I guess, if the OSHA technical standard goes into effect at the beginning of January. So they do have some lead time there. Then you can say they will have to pay because you simply can't afford it. Document it as to why it's an undue hardship for you, why you can't afford it. The key here is document, and do facts. From what budget would the payment for these come, and how much do the tests cost, and how much time would you lose with the testing, and paying them for the time to be tested, and show why you can't afford it. So, document. And I think what's important is to just take a deep breath and do that documentation like any other business cost, and show why you can't afford it, and make job by job determinations. If this is another frequent question we get, if we can only afford 10 to have 10 people tested at our expense, but we have 20 requests, how do we decide? But you have to look at the jobs, at the ability of the organization to function, and you sort of have to really make decisions based on facts, not based on assumptions. They're not easy, but that's the reality we face.
Yep. Well, Carol, thank you so much. We really appreciate your insights on these incredibly tricky questions. It's a challenge for everyone. Carol Miyaskov, joining us from the EEOC, thank you for sharing your insights on vaccine accommodation requests. I'd now like to turn the program over to my colleague, Dr. Alex Alonso, SHRM's Chief Knowledge Officer. Alex?
Thank you so much. Last week, the Occupational Safety and Health Administration released its highly anticipated Emergency Temporary Standard. The ETS requires that all unvaccinated workers must begin wearing masks by December 5th and provide a negative COVID-19 test on a weekly basis beginning January 4th. Now, it's important to keep in mind this means that unvaccinated employees must potentially pay for their weekly testing. The new rules do not apply to employees who work outdoors or who work remotely away from the other employees. Joining us today is Carla Grossenbacher, a partner at Seyfarth Shaw and chair of the Labor and Employment Practice in their Washington, D.C. office. Carla is also the lead of Seyfarth's National Workplace Privacy Group and is a nationally recognized attorney expert at the intersection of employment law and privacy law. In addition, we have Kristen White, a partner at Fisher Phillips in the firm's Denver office. Kristen counsels and defends clients in regulatory workplace safety matters and is a member of the firm's COVID-19 task force, a cross-disciplinary team of attorneys dedicated to advising employers on the many workplace law aspects of the global coronavirus pandemic. And I'd like to kick it off by asking a few questions for our members here. First and foremost, how would you advise employers with at least 100 employees to respond to these new requirements? And I'm going to start with you, Carla.
Well, I mean, you have a choice, right? There's been a stay, obviously, that most people have heard about, issued in the Fifth Circuit, but it's unclear that that would have nationwide effect, even though it's been reported as such. I would at least be making preparations to hit the deadlines if you want to wait what happens, as there are many other challenges being launched. If you're in the Fifth Circuit, maybe you can take a little respite, but I'm certain that Kristen also has some views on the subject.
Yes, thanks, Beth. I have similar thoughts as Carla that, advising that still go ahead and make some preparations. I think there's a lot of litigation left over the next month that we're going to see happen. And so employers don't want to be caught, flat-footed with these, the early December deadline. Start getting your policies prepared so that if it does go into effect, you're ready to go.
It's no secret that the White House and the Department of Labor feel fairly confident in terms of their ability to overcome any legal challenges to these new rules. But what do you think the likely impact of legal challenges will be to these new rules? And do you anticipate that the implementation may be delayed?
So I don't anticipate, I guess the easy part of that question would be I don't anticipate that they will delay implementation if the rule is upheld. I think, the White House and DOL have been pretty clear that, they think they're going to survive and that they're going to keep those deadlines. So I would anticipate that the effective dates will remain as drafted. It's possible that OSHA could put out a guidance memo as they did during COVID stating, we'll be looking at good faith efforts if people are, trying to get in compliance in January. For the legal challenges, one of the things that could be interesting to see is, a judge does, and the panels do have the option to uphold parts of the rule and not other parts. And the rule specifically provides for that, if certain parts are not upheld, that the other parts should remain. So that's something else to keep in mind, that I would be surprised if the entire rule is struck down, but, cannot predict exactly what they will do. That, people should keep in mind that they can uphold parts of it and not other parts.
For those employees that choose to test weekly rather than be vaccinated, how should employers go about documenting and storing that information?
So this is Carla. I would start from an employment law privacy perspective, which is, throughout the pandemic, employers have been collecting medical information of employees, and there are certain obligations under the ADA to keep that information confidential and treat it as a medical record, and this information is no different. And simply because it's under the OSHA ETS doesn't mean those ADA rules don't apply, and the ETS actually makes reference to them. So they need to be kept separate from the personnel file, of course, and limited access to that information. It can't be given to supervisors and managers other than to reveal to them workplace restrictions that flow from that information. I'm sure Kristen has some thoughts from the OSHA perspective.
I think that's a really good point, Carla. I like the idea of electronic systems because you can store it separately, as Carla mentioned, and making sure that you put the privacy in place that you need to, because from the OSHA perspective, they're not going to be able to take an employee's word for it as to that their test was negative. That part of the rule is they have to obtain either a copy of the vaccination record, or here with weekly testing, a copy of that test showing that it is in fact negative. So employers are going to have to figure out a way to store all of that data, especially when you're talking about weekly testing and, if you have a high number of employees doing that. But I think electronic system, it would be to an employer's benefit here, because it is going to be a lot of paperwork.
a lot of our member employers are organizations that have a mix of employees. And so they might have workers who are remote. They might have workers who operate in outdoor settings. And many of them are trying to make an understanding, if you will, or cobble together an understanding of what it is that happens or how those particular populations are impacted. So my question for you, Kristen, is, are remote and outdoor workers impacted in any way by this ETS?
Potentially not. And I say potentially not because for remote workers, they would need to stay remote, meaning that they're never coming to the office. And that is a hard line. The other for outdoor workers, again, OSHA's put a pretty hard line on this, that they must be exclusively outdoors. And so that's why I say potentially not, because, you know, as an employer, you're going to have to evaluate how often, like, for example, your outdoor workers, how often do they come to your building or to your office? You know, can you get below this? I believe there was a 10% threshold. Can you get below that 10% threshold? You know, one of the interesting parts I thought in the rule is, you know, they specifically mentioned construction sites. And I have a lot of construction employers who consider their workers to be outdoor workers. However, OSHA's addressed that and talks about it. You know, are they truly exclusively outdoors, or are they in the process of putting up a building such that they're putting up walls or putting up a ceiling, that they're no longer outdoors, and they would be covered by the ETS. You know, so that's something, you know, for employers to take a look at to see if they can fall into one of these categories. But, you know, OSHA's drawn pretty hard lines on it.
There's also the issue of, you know, people who consider themselves quote unquote remote workers, but occasionally come into the office. And there will be testing requirements for those individuals when they do in fact come to the office for whatever it is, a training session or some kind of in-person event, and they will have to test for that in advance.
So I'm going to come back to you with this question, Carla, and this is one we get often. How does the paid time off requirement differ from similar requirements issued during the pandemic?
Well, I think the major difference for me when I read the requirement was, you know, there were some states that had these requirements around giving paid time off for vaccination, but the OSHA ETS is very specific with regard to when you can and cannot force an employee to go into their own leave bank. So if someone's having adverse reaction to the vaccine, for example, if they have sick leave on the books, you can require them to use it. But if they don't, you can't force them to go into a negative leave balance. You, the employer, need to pay for that sick time. And then when you're talking about time off for vaccination, you can have employees use existing PTO if they have an overarching PTO bank that isn't specific to sick or vacation, or they have other leave for that, but you can't force them to use, for example, vacation or something like that. The employer needs to pay for the time that they spend getting vaccinated. That can't come from another bank.
Kristen, same question to you.
Yeah, I too thought it was interesting the way that OSHA had drawn some of these lines on pay. You know, one thing to keep in mind, you know, because the rule does not require paid time off for employees that are exposed to COVID or have positive cases, you know, but they specifically state there may be other laws. And so I'm in Colorado, and we still have paid COVID leave for employees that have exposure or positive cases. So just something to keep in mind, that, you know, employers want to make sure that they check their state laws. I don't think there's many left like Colorado, but just to ensure there's not other paid obligations out there.
In my role at SHRM, I lead our research function. And one of the things that we've been studying for the last year and a half is the notion of what would happen if there was a mandate to get vaccinated by employers. And we asked specifically, if we were to look back to December of 2020, one of the things that we learned was that there were roughly 28% of working Americans who said they would rather quit than be forced to get vaccinated. Now we see that actually has gone down to some degree, but there's still that kind of resistance, if you will. So I guess my question for you, and we'll start with you, Carla, do you anticipate that employees will quit rather than get vaccinated or pay to be tested each week?
Well, I actually think the OSHA ETS and Biden's executive order concerning private businesses with 100 or more employees has helped employers a lot with that issue that's concerned them throughout the pandemic of, if I put a vaccine mandate into place, will my employees quit? Because the effect of this broad-reaching mandate that reaches every company with 100 more employees is, where are they going to go? They're not going to go to a federal contractor. They're not going to go to most other employers because they're all going to have the same rule unless they're a very small company that doesn't have 100 employees. And I don't think every employee is going to have the ability to just find another job with a company that's not covered by the OSHA ETS. So in a very real sense, the Biden mandate has kind of leveled the playing field where an employer doesn't have to worry as much about an employee quitting. Doesn't mean no one will, but I think the practical effect of the executive order is going to minimize that substantially.
Kristen, what happens in states where the federal vaccine requirements conflict with state mandates?
So OSHA and the ETS had a lot of language. I think they were anticipating this. A lot of language about how federal OSHA has preempted the field, especially in states that are federal OSHA states, for example, Florida or Texas, states that have been very vocal against mandates. Those are federal OSHA states where, federal OSHA has preempted or occupied the field when it comes to workplace safety. It will be interesting in states that are state plan states, meaning states, for example, Wyoming, that also is pretty vocal against vaccine mandates. Under the ETS, those state plans have 30 days to adopt a plan that is, at least as effective as OSHA's rule. And if they don't, then the federal OSHA can, take away their state, ability to run their state plan and start running the federal OSHA in their state. We've seen that happen with Arizona on non-COVID related issues. So I think we'll see this preemption argument play out a little bit as part of the lawsuits, I would anticipate. But, the workplace safety field has been run by the federal government for a long time. So I anticipate that they would come out ahead on that side.
Carla, did you have any thoughts on this one?
Yes. We track what the states are doing in terms of anti-vaccine mandate legislation at the firm. Every week there are more and more bills being proposed. So when people ask me about, doesn't the ETS say that it supersedes, preempts, any contrary state laws, you have to wonder whether the states agree with that. Otherwise, why would they be proposing all these bills? Just a little over a week ago, Wyoming, which Kristen was just talking about, its legislature proposed a raft of anti-vaccine mandate bills. They continue this week to progress through the legislative process. So I think somewhere, somehow, some employer who doesn't want to be in that position is going to find itself potentially being the test case, and some court's going to decide whether one of these state laws actually is preempted by the OSHA ETS, because it seems like these governors who sign these bills in some of these states disagree with that notion.
So I guess my next question for you, and we'll start with you, Carla, is do you anticipate strict enforcement by OSHA with penalties assessed? And I raise this question in large part because I used to be a safety manager for an airline many, many years ago. And so I remember what it was like when OSHA would come in with penalties. And I'd love to get your perspective on this.
Well, I know Kristen will have some thoughts here too, but I would say OSHA does not have the staffing, physical ability, whatever the right words are, to aggressively enforce this given how many companies it covers, right? Every employer with more than 100 employees. So I think to some degree they'll have to rely on enforcement by public announcement, right? You go after some of the more notable, larger employers and you enforce it against them, and then everyone hears about it, and that has its own effect on enforcement. But I welcome Kristen's thoughts.
Yeah, I have similar thoughts on that as well. I think you will see that OSHA will try to make examples of certain companies that are blatantly violating the rule. in order to, have smaller companies become worried that they don't want to be the ones that are in the media. We saw during COVID 2020 that most of the time when OSHA was coming out on COVID-related issues, it involved complaints. And so, I would see it to be similar here, that because OSHA doesn't have the manpower to go and just start generally enforcing this, that they would likely go to work sites where they're receiving complaints. And that can be complaints on both sides. One, that you're not enforcing the rule, or employees that will complain that you are enforcing it. We saw that during 2020. But yeah, they'll have to decide, where they're going to put their resources, because they're not going to have the ability to simply generally apply this across the board to their work sites.
So I'm going to jump ahead here a little bit and ask, since the OSHA ETS does not require employers to pay for COVID testing, can employees receive free testing under the CARES Act?
Just because the OSHA ETS says that employers don't have to pay for the cost of testing, that does not end the inquiry for employers, because the obligation to pay for that cost is really a creature of state law. Probably half of the states in the country have laws that are either expense reimbursement laws or laws that say an employer can't shift the cost of a required medical exam to an employee. So while OSHA is saying as a matter of federal law, the employer does not have to pay for the test, employers have to look at that question under state law as well.
And Kristen, how about you?
I've been taking a similar view of it, that employers, even though OSHA has taken this view of not paying, that's not going to end the analysis, unfortunately, and that there may be other reasons, and as Carla mentioned, state law, that they may have to pay for that. So, I would think if their free testing is available to an employee, for example, here in Colorado we have free testing sites, and that you'd be able to take advantage of that. But I think, it's going to depend on, with the free testing sites, if that becomes limited to those that have exposure or not. Like here in my state in Colorado, it's not. Anyone can get a free test at any time for any reason. But, will we see that change if we start to have hundreds of thousands of employees being tested weekly?
Right, because I think one of the things that you have to keep in mind is, for example, when insurance companies pay for COVID tests, they're paying for them in a circumstance where someone has been exposed because they want to stop the spread. What we're talking about in the OSHA ETS is essentially screening testing, which I would be surprised if an insurer agreed to pay for. I think they're going to leave that squarely in the hands of potentially the employers and potentially the employees, depending on the state.
So what options concerning costs are available for employees who have to go through regular testing? And Kristen, I wonder if you have any thoughts here.
So the ETS is pretty broad as far as the different types of tests. So it doesn't just have to be the rapid test or, the PCR test that may take 2 or 3 days. They can use a home test as long as it's not both, but self-administered and self-read. So you have to work that out with the employer, if you want to use some of the home testing kits. So there are, I guess, less expensive options, but there's still significant out-of-pocket costs if you look at it on a weekly basis if an employee is paying for that him or herself.
So I'm gonna jump in and maybe ask one or two more questions that dive into the actual language of the ETS. If any employee, or if an employee primarily works from home and comes in once or twice a year, would they be required to get vaccinated or tested?
So they would, and it's only on that interval of 7 days prior to coming into the office. So they would not have to be doing it weekly, but just that, 7 days prior to the day they're going to come into the office.
Now, Carla, I'm going to ask you a question that actually sort of hit our airwaves here a little bit a while ago, and is something that came up in conversation with an employer who has a multinational organization. The question is, if you have a non-U.S. based employee who comes to headquarters in the U.S., do they have to comply with the testing or vaccination requirements? How do they go about complying with that?
That is a great question. I didn't see anything in the ETS that covered necessarily a distinction between OUS-based employees and US-based employees, but if they're an employee of the covered employer in the US, I think you would have to have them comply with the testing requirement if they're unvaccinated, as that is defined in the ETS.
So I'll jump forward just to our next question here. I guess the question I would raise is, from the ETS, we have language that speaks to specifically when federal OSHA promulgates an emergency temporary standard, state plans must either amend their standards to be identical or at least as effective as the new standard, or show that an existing state plan standard covering this area is at least as effective as the new federal standard. I know you referenced the Wyoming example, but can you give us an example that stands out of something that would be considered at least as effective as? Many of our members are wondering what that at least as effective as refers to, or looking for some guidance around that.
Sure. So this is Kristen. Since I addressed that earlier, happy to take the first shot at this one.
Yeah.
So that language is typically used by OSHA because states can implement a more restrictive plan if they want. So, for example, let's just take California. So they could have a standard that is even more restrictive than the OSHA, federal OSHA ETS. But it just can't be less. And so that's what that language typically means, as at least as effective as, is that, you can't be below the OSHA ETS. So I was trying to think about what would be as effective as vaccination or testing workers for a state plan to adopt, and I thought you could have provisions in there, with remote work, because the OSHA ETS has that as well. So I was struggling a little bit to think about how a state plan would be as effective as the federal plan and not implement at least testing for workers that are going to be working together. So I would expect, if state plans do adopt, which they're supposed to, a rule, that it would be either close to what OSHA's done or be more restrictive.
Carla, any thoughts on that one?
I agree with what Kristen said. I think it's hard to get more restrictive, especially when you think about the OSHA ETS actually says employers must have mandatory vaccination policies unless they have, the vaccination and testing. So it's hard to imagine what is more restrictive than that, except, as Kristen said, everybody just doesn't come into the office and everybody just works from home. And I don't see how a state plan basically says all employers have your employees work from home, because obviously that can't be done at every workplace.
Thank you. I'm going to jump into our final question. I guess and I'll start with you, Carla. In the ETS, we have some language that speaks to if the employer has fewer than 100 employees on the effective date of the standard would not apply to that employer as of the effective date. However, if that same employer subsequently hires more workers and hits the 100 employer threshold for coverage, the employer would then be expected to come into compliance with the standard's requirements. This is something that we've actually seen with a few of our knowledge center advisors. They get questions about this on a regular basis, and it speaks to growth, obviously, for several enterprises. But I guess the question is, define how soon after the employer hits that 100 mark, do they need to be in compliance with that standard? And Carla, I'll ask you that first.
There's nothing that I see in the ETS that's going to give a firm answer to that. And of course, you have to keep in mind that if it's an employer who wasn't covered and has now become covered and is expected to set up testing and, implement a vaccination policy, et cetera, they're going to need to be given some time. I mean, this is, an issue under the federal contractor executive order as well. And I think we go back to the point of enforcement, and Kristen mentioned this concept earlier of good faith. And I think that's what OSHA is looking for at the end of the day. So I would think if the employer acts quickly to implement the correct policies and set up the testing protocol, which takes time to do correctly, that employer is not likely to get in a bunch of trouble with OSHA as long as they are in good faith trying to make that happen as soon as practicable.
Kristen, I'm going to ask you a follow-on question here. If an employer has numerous work locations and they all have different employer identification numbers or EIN numbers, how does that affect the employee count to determine coverage? And have you seen any resources that would help companies kind of apply this rule to those that are companies with common ownership?
So on the resources, I haven't seen resources that would help them, other than, I mean, on the OSHA ETS, there is some language in the rule that talks about looking at a joint safety rule. I thought that was interesting. That's what they focused in on. So obviously having the different EIN numbers is a factor that you're going to look at, but it's not going to end your analysis of it. So you're going to want to look at, as far as this common ownership, comes down to this integrated employer, and how much, how many things are we crossing between two companies? And so, OSHA obviously has picked up, if you have a single safety person from corporate that's visiting all of your subsidiaries, that would bring you under this rule as one joint employer. So I think to me, that's going to be a real fact-specific analysis for those companies that they're going to look at. And just the last point I'd make on that is they want to make sure that they're consistent. If they've taken positions under other laws that they are a joint employer or not, that they should remain consistent with the position they take under this rule.
Thank you so much, Kristen. And I want to thank you both, Carla and Kristen, for taking time today. I know our members find this invaluable, and will use this as a resource when thinking about where they're headed in responding and being compliant to the ETS. With that, I'm going to turn it back over, and we're going to focus on some questions with my partner in crime, Amber Clayton, the director of the SHRM Knowledge Center. Welcome aboard, Amber.
Thank you very much for having me today.
Well, we appreciate you being here. So just like we do with other webcasts, we're going to go ahead and play 20 questions, I think, here. But I'd like to go ahead and do a deep dive with a couple different questions. So let's jump in here, because I think that there's some information that we've gotten in terms of numerous inquiries, and I'd really like to focus on those things that we've fielded since the release of the ETS. So first question for you, do employers have to count part-time employees when determining if they have 100 employees?
Well, that's a good question. So we have received numerous questions from employers since the ETS was released, and many of them are just trying to determine whether or not they're required to comply with the ETS. And so that's been one of the questions as to, whether or not they need to count the part-time employees. And the answer is yes. Those part-time employees do count towards the 100 employee limit. And as Carla and Krista mentioned, there's no indication in the ETS that it has to be part-time, working a certain number of hours. So basically it's part-time and full-time are counted towards the 100 employee threshold, regardless of the hours that are worked.
I'm going to jump in here and ask you another question. Do independent contractors get counted when determining if they are 100 employees or more?
Another good question, and that is no. The independent contractors are not actual employees of the organization, so they don't count towards the total number of employees.
What about temporary employees or seasonal workers? Do they count? And I ask this in large part because we talked a lot about part-time, we talked about remote, working outdoors, but this is one we didn't get to with Carla and Kristen.
Yeah, absolutely. And as we get into the holiday season, more employers actually hire seasonal workers. So if they're employed directly by the company, they actually are counted towards that 100 employee count threshold. If they're employed by the staffing agency would actually count these employees toward their 100 employee count.
I'm going to ask this as well, and this is one that I think is sort of an interesting one, because we really haven't discussed this more broadly with anyone. If we didn't have a policy of vaccination previously, how do we find out who is vaccinated?
Yeah, that's a really good question. So even before the ETS, employers were trying to figure out whether or not employees were vaccinated, because they were just starting to implement whether or not they were going to do the mandated vaccine or encourage their employees to get the vaccine. So under federal law, we know that employers can ask employees if they've been vaccinated against COVID-19. The state and local laws, of course, might be different, so you want to review your area's laws. And employers who are covered by the ETS, they're going to need to determine their employee's vaccination status and collect proof of vaccination. So the ETS preempts or overrides the state or local laws that don't allow the employers to ask employees for the vaccination status or proof of it. Some employers we know have used surveys. I know SHRM, we have a survey on our website, a template that members can use. They use surveys to make this determination. What employers should be cautious about, though, is not to ask any medical information that may run afoul of laws like the Americans with Disabilities Act, the ADA, or the Genetic Information Non-Discrimination Act, GINA. So they shouldn't be asking about medical history or anything outside of details regarding the vaccination, where they got it, what the date was, etc.
What is acceptable proof when we're talking about a vaccination? Does it have to be a hard copy? Can it be electronic? And I'm telling you, I've seen this all over the place. I myself have attended conferences recently where people are asking me for an electronic health pass or what is tantamount to an immunization passport. And I'd love to kind of get a sense from you. What is acceptable in relation to the ETS?
Well, Kristen and Carla actually mentioned that it could be hard copy or electronic. Their recommendation was to be electronic just for tracking purposes, that it would be easier to administer and keep records if they're electronic. So it can be either. With electronic, it could be something like a photo, a scanned image, or a PDF. And as far as what's acceptable proof of vaccination, the record of immunization from a healthcare provider or pharmacy is sufficient. It could be a copy of the COVID-19 vaccination record card, a copy of medical records documenting the vaccination. It could be a copy of immunization records from a public health, state, or tribal immunization information system, or any other official documentation that contains that type of information. Now, if someone has lost their card or they can't find it, obviously lost it, a signed and dated employee attestation is acceptable in instances where that might happen. Now, normally those employees should be going back to the provider of the vaccination first to see whether or not they can get a copy of it, but the signed attestation could be sufficient for the employer as well. The one thing to also keep in mind is that similar to I-9s where you're identifying the documents or looking at the documentation for employment, in this particular case, you can't just look at it and mark the information down. You actually need to retain a physical or electronic copy and keep that through the duration of the ETS.
Okay. Can we accept proof of vaccination from an employee who has received it outside the U.S.?
Yeah, so Carla and Kristen just talked briefly about the global employees when you have a U.S. employer and employees overseas who come over where they'll need to be tested. And interestingly, the one thing that wasn't mentioned is if where they would get that testing and the vaccinations. So if there was an employee who did receive it outside the U.S., there are some guidelines within the ETS that says that if it's approved or authorized for emergency use by the FDA, and it's listed for emergency use by the World Health Organization, or it's administered as part of a clinical trial at a U.S. site, and of course there's additional information or criteria around that particular piece of it, that an employer can actually accept that as proof of vaccination.
This is an interesting one. I think this is one where we've seen a few kind of examples pop up of late, some more famous than others. But what should we do if an employee refuses to comply with our mandatory vaccine policy?
Yeah, this is a really good question. This has actually come up prior to the ETS being released, when those employers were looking at whether or not they were going to have a mandated vaccine policy. And when employers do make the vaccines a condition of employment, absent any medical or religious accommodations that might need to be made under the ADA or Title VII of the Civil Rights Act, those individuals who decline it, for example, if they decline it because they don't believe in getting vaccines or whatever their reason is for not getting the vaccine, an employer could, now this is up to the employer, they can accept the weekly testing. They could allow those individuals who don't get the vaccination to take a leave of absence. They could transfer them to another position, maybe exclusively outdoors or, working exclusively from home, or they could terminate their employment. However, termination is not the ideal thing, of course. I mean, right now employers are struggling to retain employees and to acquire new hires. So, employers should be considering that when making those determinations. And they also should work with their legal counsel just to determine if there's any risk in their particular situations.
Now, you referenced risk, and I just want to throw in one kind of wrinkle here for you. What about in a unionized setting? What kind of guidance would you give an employer in a unionized setting?
Yeah, that's a really good question. Of course, in the unionized session, you have a collective bargaining agreement. So, of course, you want to review the CBA to determine what the criteria, what the rules are, policies around vaccinations and terminations and disciplinary action and those types of things. So that would be what I would recommend, is just look to that first before making any type of decisions or taking any action.
And if I could go ahead and just have, you think about this and maybe give us a quick answer here. What is the number one piece of guidance that you'd offer any employer who's still implementing or trying to determine whether or not the ETS really applies to them? And let's say that they're conducting their analysis. What is it that you would give or offer as guidance to any one employer as they go about embarking upon this, the compliance with this particular ETS?
Read the FAQs from OSHA. Definitely read it thoroughly. Read the regulations. Those will help you determine whether or not you are required to comply with the standards. Work with your legal counsel. Work with your employees and determine what might be best for your organization while still maintaining compliance with the ETS, as well as any other state, local leave laws, things of that nature. And keep up to date on what's happening, because as we know, things are changing constantly. So you want to keep up with information from SHRM as well as OSHA, Department of Labor.
I'd actually also kind of focus on how well your data collection or your data systems are in terms of ensuring that you have what you need to be able to be compliant. It strikes me that this particular ETS really does put an emphasis on how well you keep your data and what you do with your data. So I hear those with limited data capturing capabilities kind of cowering, but I tell you, it really does speak volumes to have that information. Thanks so much, Amber. I really appreciate you taking the time to be here and all the work that you and your team do in terms of answering inquiries of our more than 300,000 members. With that, I'm going to go ahead and turn it back over to Mike Frost.
Thank you, Dr. Alonso. We are bringing this program to a close, but please stick with us as we have a couple of announcements, including information on the recertification credit you've earned.